God damn it, dude. What the
You're under arrest.
You caught me speeding. Give me a ticket so I'll be on my way.
There are untreated mental health concerns, and the nature of his criminal history and criminal contacts suggests that there may be significant mental health, untreated mental health issues.
I appreciate you behaving yourself this way, because just listen, because you're coming in hot like you did before. I'm just gonna let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that. And
Mr. 8 George Charles Henry 137.
Hi, I'm Brian Cowan, Reading Police Department. The reason I stopped you is you're going about 60 miles an hour on Pacelli as you passed me. Can I see your license, registration, and insurance, please?
I'm not in the process of conducting business.
Okay, we're not going to play that game, sir. So if you don't want to identify yourself, I'm just going to place you under arrest and tow your vehicle. Okay?
I'm traveling right now.
Yeah, we're not going to do that. Okay? So I need to see your ID, and I need to see the registration and insurance on your vehicle, okay? And you're a grown adult, so you're going to make an adult decision right now. Okay? So that's up to you. What do you want to do? Okay, you're going to be placed under arrest. Step out of the vehicle. Out of the vehicle.
Hey, bro.
Edward 47. I'll take a 1025. Don't.
Trying. Hemophilia, bro. Ow, that hurts.
Don't.
Let me get out.
Don't. Get out right now. Undo your seatbelt. Undo your seatbelt and get out.
I'm traveling, sir.
Undo your seatbelt.
I'm not
And get
conducting
out
business
of the vehicle.
right
You are under arrest.
now. I'm not conducting
Get
business.
out of your vehicle. Out of your vehicle. Undo your seatbelt. Do you understand me? Do you understand me? Undo your seatbelt and step out of the vehicle.
Brian, dude.
Okay?
10-8, call me 85 Edward 47, I think I'm closer.
Undo your seatbelt and get out.
Man.
Undo your seatbelt
No.
and get out of the vehicle.
Break my arm.
I'm not going to break your arm. I don't want to. I want you to get out of the vehicle. Do you not want to get your seatbelt off first? Why don't you just get your seatbelt off and we'll do this?
Breaking my arm, bro.
No.
God damn it, dude. I'm not
You're under
conducting
arrest.
business.
You're under arrest.
I'm not conducting business.
You're under arrest. Okay?
No, for what? Show me the magistrate.
Yeah, that's where we're going to go. You don't want to identify yourself, so we're going to do that. Okay? You don't get to do this, sir.
You don't either, bro. You don't
Yeah.
get to go in my car and me out and break my arm.
I'm asking you to step out.
I'm asking you to let go of my arm.
I'm not going to do that.
I can't reach my seatbelt.
You can do it with your right arm.
No, I can't.
You can do it with your right arm. So as soon as the other officer gets here, we're going to pull you out and put you in handcuffs, okay?
Right. For traveling, yeah.
Yep.
I'm not in the process of conducting business.
47. I'll take another unit.
Get off me, dude! What the is your problem?
Don't.
Get the off me!
Stop.
Get off me, dude!
Stop. Stop.
No!
Stop.
God damn it, dude! What the
Resisting
What
me.
the
Stop.
fuck, dude?
You're
This
under-
is over there, dude!
Stop.
What the No, dude! You're attacking me, dude!
Stop.
No! Dude! You stop! Get the dude! God damn it, dude!
Stop.
No! You
Stop.
You up!
You're not going anywhere.
I'm not arrested.
You're under arrest.
For what?
You're under arrest.
You caught me speeding. Give me a ticket so I'll be on my way.
Stop!
I got you.
Stop!
What are you guys doing, dude?
You're under arrest.
Smash my head. Stop resisting. And put me under arrest. Magistrate.
You are under arrest.
Got it?
What the fuck is wrong with you guys? Here, let's get this arm. Okay.
Stop.
You're good, bro. Stop.
I'm burning my face.
All right. Got it? No, it's on my short. This one's not
Face is burning.
I got you.
I'm traveling.
Thanks. Nope. My car.
Look straight. No knives on you, anything?
I'm traveling right now.
You're traveling to jail right now.
Not in the process of conducting business right now. Take me to see the magistrate, please.
Sit down. Feet in.
Do you have any sanitizer stuff? Wipes?
I don't know if I have any white.
Start grabbing witness.
All right, thanks. You still need some hand sanitizer?
Yeah, if you have some.
Yeah.
Thanks. Yeah, like.
Yep. Cool beans.
Yeah, I saw you. I was driving this way and this guy said, "Hey, needs help," so I pulled over. And... Oh well.
Huh.
So, I'm glad I could help.
Yeah, me too. I'm Brian.
My You good?
Yeah, I'm fine.
Okay.
No, I got it. I just need, you have his ID and stuff, this guy's?
Yep. Let me run it real quick and we'll need a
What's his name?
Frederick Phillips. 6 How long were you struggling for with them?
Oh, just actually right when you pulled up is when, because I had him in a twist lock.
Yeah.
And I was just holding there waiting for another unit.
Yeah.
And then he kept trying to pull away, and he tried trying to reach him undo his car, undo his keys, and then he just went crazy.
Yeah.
So good times.
Good?
Yeah. He's a constitutionalist, so he'll have time to take care of that in jail. Cool. If you want to just write his name down.
Yeah, what's your name, brother?
Or actually, I just didn't have I left all my paper and stuff up.
Yeah, I got it.
No, let me, I'll do it so we don't have to all do subs and stuff. Oh, yeah.
Clear local TLC, negative SLF, 27.
Cool.
Well, 2 8, I'll do stuff. I gotta work on statements.
Okay, cool. Cool. What's that? No, I don't think so. I don't think so. Okay. What's that, sir? Okay, yeah, your car's gonna get towed.
So, really nothing.
What's going on? Actually, hold on.
Good?
Yeah, cool. I'm good. I got citizens stopping to help, you know? That's how desperate I looked.
How are you? What was the guy doing?
Yeah, you.
So what do you need?
I need to be seen, see the magistrate and show.
Yeah, you're gonna go to jail.
Show my victim. Where's my victim right now?
Me.
I'm just traveling.
Yeah, you're traveling to jail.
I'm not in the process of conducting business.
Perfect.
I'm a private American.
Okay, cool. Anything else? You're under
I'm
arrest?
ready to see the judge.
Yeah, whenever the jail gets you over to the jail or to the judge, absolutely.
I'll be able to see him
Okay.
right now.
Perfect. That's a good one.
Yeah. All right.
Thanks, brother.
Yep.
Len Stringer, 24-01173.
Good morning, Your Honor. Samira Malus on behalf of the people.
Good morning, Judge. For the record, David M. Sunuko appearing on behalf of Mr. Stringer.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Lendarius Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I am the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. I have an individual before me that is listed as an Oakland County Jail inmate by the name of Len Stringer. I have a case that's been assigned to this court that where the defendant's name is Len Stringer. Mr. Sunuko, are you assigned on this case?
I am, Judge.
Okay, and you were assigned to the Stringer case, correct?
That's correct, Judge.
Okay, so that's enough for me to conduct this hearing today. Now let's walk through this. Miss Montlewis, have you provided discovery to Mr. Sunuko?
Your Honor, I didn't have an attorney listed. I believe if he filed, he may have just received written discovery. I didn't have that in my information, but give me 1 second to confirm. I'm just going to make one click.
In the meantime,
I do have written discovery, Judge.
So, yeah, it sees that he was provided with written discovery on June 26th.
Okay, so Mr. Sunuko, have you had a chance to talk to the defendant at all?
I did, Judge. I met with him at the Oakland County Jail.
All right, and so
Tuesday.
So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Montlewis, can you prepare an order for competency review?
Yes, Your Honor.
All right. I agree. I think that that's appropriate at this time. I recognize that the defendant has made a request to have Mr. Sunuko removed from the case based on the information, though, that I've sort of observed at this time, as well as information received by Mr. Sunuko. I remain unconvinced that those statements are anything other than a manifestation of what might be a competency issue. And so I'm gonna wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sunuko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels, excuse me,
competency evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in
And I
your
would
defense.
want to withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number. He did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
So I do have, in addition to the information that's been provided, I have a recommendation for pretrial services that suggests that there are untreated mental health concerns, and the nature of his criminal history and criminal contacts suggests that there may be significant untreated mental health issues. So, Mr. Stringer, I've heard your concern at this time. I'm not going to grant your request until I get a better idea of what your current mental health status is. So the request at this time is denied, but I will consider it again after an evaluation is done.
Hey, so who is the judge on my mental health? Because you can't obviously be a judge because, sir, I'm with my law, sir. So first off, I do not acknowledge myself to be Lindell Stringer, the corporation in capital letters. No, sir.
I appreciate that, and that's why I let you make a record, and I appreciate that. I just, based on what I've seen, I disagree with your position right now, and we'll get you evaluated.
You cannot.
That's enough for now, and then we'll have you evaluated by the evaluated by the forensic center, and we'll go from there. Thank you, for Mr. Sunuko. Bond is continued.
Do we have a new date, Judge?
We'll set it 90 days out.
Very good. Thank you, Judge.
Thank you.
Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date and time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I don't understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the noon staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive, and I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Houk's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, account of felonious assault, which assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. And under those circumstances, and I forgot, I think you had mentioned that before, that with that, okay. So, Mr. Styron, you're requesting an adjournment of the proceeding so you can get through that. Is that okay? How far? And I guess I was unclear. You have access to the body cam.
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it.
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about
Officer Hooks, yes.
Okay.
And I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video? Because
so originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
gotcha.
Prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to try to. Okay.
Flint's definitely provided direction in regards to how I can go about getting this.
All right. Okay. So we'll need to then adjourn that. Have you? Well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a...
No, that's fair. That's fair.
And then also...
But you don't know total... You don't know total time how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jail's addressed. So yeah, there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating a cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic and
okay, I got you.
Energy in that.
What do we
that as well?
What do we look like on the 6th? Well, we've got stuff. It's a day like today. I got stuff in the morning, but then
So
on the 6th,
so far it's 2 pieces in the morning.
2, and then I got that at 1. But if I set this at 1, the expungement should set this at 2.
And as of right now, there's no expungements actually scheduled.
Got it. Okay. Okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me?
You got all of the discovery. Like you got the, as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th. (2024) at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready. You know,
fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no notification from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to amend the information and serious charges against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. I said I meant legally in the courts, which he iterated on his body cam. So according to the body cam video, he is fully aware that I meant legally through the court process. And also, I believe in the police report, you sit there for a welfare check with a possible wrong domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my appearance and description, based on who he was looking up in his talent or the name system or whatever it is they use in the police cruiser. Make sure they iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. And sorry,
go ahead.
Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intention of running or trying to avoid it at all. And I think my actions would have sued such.
Okay. In this matter, I'm not going to at this point change your bond, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other, going through the things, that it's been a civil conversation with you.
The sovereign citizen mindset can make every courtroom instruction feel personal instead of procedural. But the danger is that emotional resistance starts creating legal evidence against you. The judge is no longer only evaluating the charges, he's evaluating whether the defendant can follow court structure safely and predictably.
To try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I would agree with what Ms. Hughes has said, and that is that if your medical, or to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and trying to represent myself.
Oh no.
And in regards to the medical thing, I reported this in May. It took until I got blood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. And I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom toward this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. And since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even opportunities.
No, there were a couple of adjournments because of that. Okay. But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
All right. Envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
No, down there.
I got about $500 in back. That okay. Why? No, I'm just saying, if I can sell them for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
Perfect. Thank you.
Okay,
Yeah.
Mr. Syra, I appreciate you behaving yourself this way, because just listen. Because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. All the other judges I've ever had going front of, whether traffic or Miss Fink that was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
she's much nicer than I am. And so she has patience. Sometimes I don't.
Fair enough.
So you got to take it as it is. All right. Thank you. You do the same.
Thank you.
Across all three situations, the biggest mistake was not the original stop, the hearing, or even the argument itself. It was the decision to turn process into conflict. In the traffic stop, the moment the driver refused to identify himself and switched into sovereign citizen language like traveling and not conducting business, the encounter stopped being about a speeding ticket. From that point forward, the officers began treating the situation as a compliance and safety problem instead of a traffic violation. That shift changed the entire outcome. In the competency hearing, the judge was not arguing politics or ideology. He was focused on one legal question: can the defendant understand the proceedings and assist in his own defense? The more the defendant rejected the court's identity and authority structure, the more the judge viewed competency review as necessary protection for the case itself. And in the final hearing, the court showed something many people misunderstand about judges. The judge did not deny bond only because of the allegations. He repeatedly pointed back to courtroom behavior, credibility, and whether he believed the defendant would follow instructions if released. That is where sovereign citizen tactics often collapse strategically. The courtroom measures conduct, not personal belief systems. A lot of people think these cases are about winning arguments. Most of the time, they become about whether the person can operate inside the legal process without escalating their own risk. And once the court starts questioning judgment instead of just facts, every future decision becomes heavier.